It is your favorite auditor's favorite auditor, Audit Dim, the one who encourages you to audit them. Audio loud and clear. The audio is being tested. Favorite auditor, Audit Dim. Yes, clear, loud and clear. Alrighty, folks, we're just going to be reviewing some case law. This stream is not legal advice, nor is this any tax or miscellaneous study. This is just for educational and entertainment purposes. This is case study, case law. So it's not for on, like I said. It's going to be extensive and quite long. But we're going to go ahead and give it a listen because there's a lot to gain. And this is actually a landmark. I believe it's one of the landmark cases. It has to do with public access, government accountability, Freedom of Information Act, etc., etc. Solus, hey, how's it going? Soila, or Soil accountability. Anyhow, without further ado, we are going to get right to it. The file is sent to the Office of Appeals in the General Counsel's office, and the Appeals Committee then decides. National Labor Relations Board et.al. v. Sears, ROEBUCK, and CO. Certiorari to the United States Court of Appeals for the District of Columbia Circuit. Number 73 to 1233. Argued January 14, 1975. Decided April 28, 1975. Under the procedure for adjudicating unfair labor practice cases under the National Labor Relations Act, if a National Labor Relations Board regional director, with whom unfair labor practice charges are filed in the first instance and to whom the NLRB's General Counsel has delegated the initial power to decide whether or not to issue a complaint, believes that the charge has no merit, the charging party has a right to appeal to the General Counsel. If this right is exercised, the file is sent to the Office of Appeals in the General Counsel's office, and the Appeals Committee then decides either to sustain or overrule the regional director, and sets forth the decision and supporting reasons in an appeals memorandum, which is cleared through the General Counsel and sent to the regional director, who must follow its instructions. In addition to this appeals process, the General Counsel requires the regional director, before reaching an initial decision in connection with unfair labor practice charges raising certain issues, to submit the matter to the General Counsel's advice branch, and in other kinds of unfair labor practice cases, the regional directors are permitted to seek the advice branch's advice. The advice branch, after studying the matter, makes a recommendation to the General Counsel, who then makes a final determination, which is communicated to the regional director by way of an advice memorandum. Depending upon the conclusion reached in such memorandum, the regional director will either file a complaint or notify the complaining party of the decision not to proceed and of his right to appeal. Respondent, after the General Counsel had declined to disclose all advice and appeals memoranda pertaining to certain matters issued within a certain number of years, filed suit to require disclosure of such memoranda, alleging violations of the Freedom of Information Act, 5 U.S.C. 552. The District Court granted respondent's motion for a summary judgment, holding that the advice memoranda were instructions to staff that affect a member of the public required. Syllabus. To be disclosed under 552, that the appeals memoranda were final opinions required to be disclosed under 552. and that both kinds of memoranda were not exempt from disclosure as intra-agency memorandums under 552. The Court of Appeals affirmed without opinion. Held. 1. Exemption 5 can never apply to final opinions, which not only invariably explain agency action already taken or an agency decision already made, but also constitute final dispositions of matters by an agency. pp. 150-154. 2. Exemption 5 covers the attorney work product rule, which clearly applies to memoranda prepared by an attorney in contemplation of litigation, and setting forth the attorney's theory of the case and his litigation strategy. pp. 154-155. 3. Those advice and appeals memoranda that explain decisions by the General Counsel not to file a complaint are final opinions made in the adjudication of cases within the meaning of 552, and hence fall outside the scope of Exemption 5 and must be disclosed. pp. 155-159. In the case of decisions not to file a complaint, each of such memoranda affects as final a disposition as an administrative decision can, and disclosure of these memoranda would not intrude on pre-decisional processes, nor would protecting them improve the quality of agency decisions within the purposes of the executive privilege embodied in Exemption 5. Since when the memoranda are communicated to the regional director, the General Counsel has already reached his decision, and the regional director has no decision to make, but is bound to dismiss the charge. p. 155. Moreover, the General Counsel's decisions not to file complaints together with the advice and appeals memoranda explaining them are precisely the kind of agency law in which the public is so vitally interested, and which Congress sought to prevent the agency from keeping secret. pp. 155. pp. 155-157. Advice and appeals memoranda that explain decisions by the General Counsel to file a complaint and commence litigation before the NLRB are not final opinions made in the adjudication of cases within the meaning of 552 and do fall within the scope of Exemption 5. pp. 159-160. The filing of a complaint does not finally dispose even of the General Counsel's responsibility with respect to the case, since the case will be litigated before and decided by the NLRB. Syllabus. And the General Counsel will be responsible for advocating the charging party's position before the NLRB. p. 159. Since the memoranda will also have been prepared in contemplation of the upcoming litigation, They fall squarely within Exemption 5's protection of an attorney's work product. And at the same time, the public's interest in disclosure is substantially reduced by the fact that the basis for the General Counsel's decision to file a complaint will develop in the course of litigation before the NLRB, and that the law with respect to these cases will ultimately be made not by the General Counsel but by the NLRB or the courts. pp. 159 to 160. 5. The documents incorporated by reference in non-exempt advice and appeals memoranda lose any exemption they might previously have held as intra-agency memoranda under Exemption 5. And if an agency chooses expressly to adopt or incorporate by reference an intra-agency memorandum previously covered by Exemption 5 in what would otherwise be a final opinion, that memorandum may be withheld only on the ground that it is covered by some exemption other than Exemption 5. p. 161. 6. Petitioners are not required to produce or create explanatory material in those instances in which an appeals memorandum refers to the circumstances of the case. Nor are they required to identify after the fact those pre-existing documents that contain the circumstances of a case to which an opinion may have referred, and which are not identified by the party seeking disclosure. pp. 161 to 162. 7. This court will not adjudicate petitioners' claim that the advice and appeals memoranda are exempt from disclosure under 5 U.S.C. 552 as investigatory files compiled for law enforcement purposes. That claim was not made in the district court, and although it was made in the Court of Appeals, that court affirmed without opinion on the basis of its prior decision in another case not involving Exemption 7, and it is therefore not clear whether that court passed on the claim. Moreover, Congress passed a limiting amendment to Exemption 7 after petitioners filed their brief, and thus any decision of the Exemption 7 issue in this case would have to be made under the exemption as amended, which could not have been done by the courts below. pp. 162 to 165. 8. Nor will this court reach petitioners' claim that the advice and appeals memoranda are exempt from disclosure under 552 as documents related solely to the NLRB v. Sears, ROEBUCK, and CO. 132 opinion of the court. Internal personnel rules and practices of an agency, that claim not having been raised below. p. 165. 9. Petitioners claim that the documents incorporated by reference in advice and appeals memoranda, which were previously protected from disclosure by Exemption 7, should not lose their exempt status by reason of incorporation, has merit since a document protected by Exemption 7 does not become disclosable solely because it is referred to in a final opinion, and accordingly the case must be remanded to the district court for a determination whether such documents are protected by Exemption 7, as amended. pp. 165 to 167, 156 U.S. App. DC 303, 480 F 2D 1195, affirmed in part, reversed in part, and remanded. WBSRI J. delivered the opinion of the court, in which Douglas, Brennan, Stewart, Marsnall, Blackman, and Rehnquist J.J. joined. Berger, C.J. concurred in the judgment. Powell J. took no part in the consideration or decision of the case. Deputy Solicitor General Friedman argued the cause for petitioners. With him on the briefs were Solicitor General Bork, Alan Abbott Tuttle, Peter G. Nash, John S. Irving, Patrick Hardin, and Norton J. Comey. Gerard C. Smetana argued the cause for respondent. With him on the brief were Lawrence M. Cohen, Jeffrey S. Goldman, and Alan Raywood. Mr. Justice C. E. Witt delivered the opinion of the court. The National Labor Relations Board and its General Counsel seek to set aside an order of the United States District Court directing disclosure to respondent, Sears, ROEBUCK & Co., pursuant to. Briefs of amici curiae urging affirmance were filed by Milton Smith and Jerry Cronenberg for the Chamber of Commerce of the United States, by Carol A. Cowgill, Peter H. Schuck, Marvin M. Karpatkin, and Melvin L. Wolfe for the American Civil Liberties Union et al., and by Alan B. Morrison for Freedom of Information Clearinghouse. Opinion of the Court. The Freedom of Information Act, 5 U.S.C. 552, of certain memoranda, known as advice memoranda and appeals memoranda, and related documents generated by the Office of the General Counsel in the course of deciding whether or not to permit the filing with the Board of Unfair Labor Practice complaints. The Act's background and its principal objectives are described in EPA v. Mink, 410 U.S. 73, 79-80, and will not be repeated here. It is sufficient to note for present purposes that the Act seeks to establish a general philosophy of full agency disclosure, unless information is exempted under clearly delineated statutory language. S. Rep. No. 813, 89th Song. First Session 3 EPA v. Mink Supra at 80. As the Act is structured, virtually every document generated by an agency is available to the public in one form or another, unless it falls within one of the Act's 9 exemptions. Certain documents described in 5 U.S.C. 552, such as rules of procedure, must be published in the Federal Register, others, including final opinions, made in the adjudication of cases. Statements of policy and interpretations which have been adopted by the agency, and instructions to staff that affect a member of the public, described in 5 U.S.C. 552, one must be indexed and made available to a opinion of the court. Member of the Public on Demand H.R. Rep. No. 1497, 89th Song. 2D Session 8. Finally, and more comprehensively, all identifiable records must be made available to a member of the public on demand. 5 U.S.C. 552. The Act expressly states, however, that the disclosure obligation does not apply to those documents described in the 9 enumerated exempt categories listed in 552. 3. Sears claims, and the courts below ruled, that the memoranda sought are expressions of legal and policy decisions already adopted by the agency and constitute final opinions and instructions to staff that affect a member of the public, both categories being expressly disclosed. Invasion of personal privacy. An agency may delete identifying details when it makes available or publishes an opinion, statement of policy, interpretation, or staff manual or instruction. Title 5 U.S.C. 552 at the time in question provided in pertinent part, except with respect to the records made available under paragraphs and of this subsection. Each agency, on request for identifiable records made in accordance with published rules stating the time, place, fees to the extent authorized by statute, and procedure to be followed, shall make the records promptly available to any person. The relevant exempt categories are those described in exemptions 2, 5, and 7. With respect to them, the statute provides. This section does not apply to matters that are related solely to the internal personnel rules and practices of an agency. Interagency or intra-agency memorandums or letters which would not be available by law to a party other than an agency in litigation with the agency. Investigatory files compiled for law enforcement purposes except to the extent available by law to a party other than an agency. Opinion of the Court. Able under 552 of the Act, pursuant to its purposes to prevent the creation of secret law. In any event, Sears claims the memoranda are non-exempt identifiable records which must be disclosed under 552. The General Counsel, on the other hand, claims that the memoranda sought here are not final opinions under 552, and that even if they are identifiable records otherwise disclosable under 552, they are exempt under 552, principally as intra-agency communications under 552, made in the course of formulating agency decisions on legal and policy matters. Crucial to the decision of this case is an understanding of the function of the documents in issue in the context of the administrative process which generated them. We deal with this matter first. Under 1 Et. of the National Labor Relations Act as amended by the Labor Management Relations Act, 1947, 61 Stat. 136-29. USC 151 Et. The process of adjudicating unfair labor practice cases begins with the filing by a private party of a charge, 3 and 10, 29 USC 153 and 160, 29 CFR 101.2, Auto Workers v. Schofield, 382 U.S. 205, 219, NLRB v. Indiana and Michigan Electric Co., 318 U.S. 9, 17-18. Although Congress has designated the Board as the principal body which adjudicates the unfair labor practice case based on such charge, 29 U.S.C. 160, the Board may adjudicate only upon the filing of a complaint. And Congress has delegated to the Office of General Counsel on behalf of the Board the unreviewable authority to determine whether a complaint shall be filed. 29 U.S.C. 153, Vaca v. Sipes, 386 U.S. 171, 182. In those cases in which he decides that a complaint shall issue, the General Counsel becomes an advo. Opinion of the Court. Cate before the Board in support of the complaint. In those cases in which he decides not to issue a complaint, no proceeding before the Board occurs at all. The practical effect of this administrative scheme is that a party believing himself the victim of an unfair labor practice can obtain neither adjudication nor remedy under the labor statute without first persuading the Office of General Counsel that his claim is sufficiently meritorious to warrant Board consideration. In order to structure the considerable power which the administrative scheme gives him, the General Counsel has adopted certain procedures for processing unfair labor practice charges. Charges are filed in the first instance with one of the Board's 31 regional directors, to whom the General Counsel has delegated the initial power to decide whether or not to issue a complaint. 29 CFR 101.8, 102.10. A member of the staff of the regional office then conducts an investigation of the charge, which may include interviewing witnesses and reviewing documents. 29 CFR 101.4. If, on the basis of the investigation, the regional director believes the charge has merit, a settlement will be attempted or a complaint issued. If the charge has no merit in the regional director's judgment, the charging party will be so informed by letter with a brief explanation of the reasons. 29 CFR 101.6, 101.8, 102.15, 102.19. In such a case, the charging party will also be informed of his right to appeal within 10 days to the Office of the General Counsel in Washington, D.C. 29 CFR 101.6, 102.19. If the charging party exercises this right, the entire file in the possession of the regional director will be sent to. Opinion of the Court. The Office of Appeals in the General Counsel's office in Washington, D.C. The case will be assigned to a staff attorney in the Office of Appeals, who prepares a memorandum containing an analysis of the factual and legal issues in the case. This memorandum is called an Agenda Minute I, and serves as the basis for discussion at a meeting of the Appeals Committee, which includes the Director and Associate Director of the Office of Appeals. At some point in this period, the charging party may make a written presentation of his case, as of right, and an oral presentation in the discretion of the General Counsel. 29 CFR 102.19. If an oral presentation is allowed, the subject of the unfair labor practice charge is notified and allowed a similar but separate opportunity to make an oral presentation. In any event, a decision is reached by the Appeals Committee, and the decision and the reasons for it are set forth in a memorandum called the General Counsel's Minute, or the Appeals Memorandum. This document is then cleared through the General Counsel himself. If the case is unusually complex or important, the General Counsel will have been brought into the process at an earlier stage and will have had a hand in the decision and the expression of its basis in the Appeals Memorandum. In either event, the Appeals Memorandum is then sent to the Regional Director, who follows its instructions. If the appeal is rejected and the Regional Director's decision not to issue a complaint is sustained, a separate document is prepared and sent by the General Counsel in letter form to the charging party, more briefly setting forth the reasons for the denial of his appeal. The Appeals Memo. Opinion of the Court. Randa, whether sustaining or overruling the regional directors, constitute one class of documents at issue in this case. The appeals process affords the General Counsel's office in Washington some opportunity to formulate a coherent policy and to achieve some measure of uniformity in enforcing the labor laws. The appeals process alone, however, is not wholly adequate for this purpose. When the regional director initially decides to file a complaint, no appeal is available. And when the regional director decides not to file a complaint, the charging party may neglect to appeal. Accordingly, to further fair and uniform administration of the Act, the General Counsel requires the regional directors, before reaching an initial decision in connection with charges raising certain issues specified by the General Counsel, to submit the matter to the General Counsel's Advice Branch, also located in Washington, D.C. In yet other kinds of cases, the regional directors are permitted to seek the counsel of the Advice Branch. When a regional director seeks advice from the Advice Branch, he does so through a memorandum which sets forth the facts of the case, a statement of the issues on which advice is sought, and a recommendation. The case is then assigned to a staff attorney in the Advice Branch, who researches the legal issues presented by reading prior board and court decisions and prior advice determinations in similar or related cases. Statement 3076 1 and reports orally or in. Opinion of the Court. Writing to a committee or agenda made up of various high-ranking members of the General Counsel's office. The committee recommendation is then arrived at and communicated to the General Counsel, together with the recommendation of the regional director and any dissenting views in the committee. In special cases, the General Counsel may schedule special agendas and invite other staff members to submit their recommendations. In either event, the General Counsel will decide the issue submitted, and his final determination will be communicated to the Regional Director by way of an advice memorandum. The memorandum will briefly summarize the facts, against the background of which the legal or policy issue is to be decided. Set forth the General Counsel's answer to the legal or policy issue submitted together with a detailed legal rationale, and contain instructions for the final processing of the case. IBID. Depending upon the conclusion reached in the memorandum, the Regional Director will either file a complaint or send a letter to the complaining party advising him of the Regional Director's decision not to proceed and informing him of his right to appeal. It is these advice memoranda which constitute the other class of documents of which Sears seeks disclosure in this case. 2. This case arose in the following context. By letter dated July 14, 1971, Sears requested that the General Counsel disclose to it pursuant to the Act all advice and appeals memoranda issued within the previous 5 years on the subjects of the propriety of withdrawals by employers or unions from multi-employer bargaining disputes as to commencement date of negotiations, or conflicting interpretations in any other context of the boards. Opinion of the Court. Retail Associates Rule. The letter also sought the subject matter index or digest of advice and appeals memoranda. 0. The letter urged disclosure on the theory that the advice and appeals memoranda are the only source of agency law on some issues. By letter dated July 23, 1971, the General Counsel declined Sears' disclosure request in full. The letter stated that advice memoranda are simply guides for a regional director, and are not final, that they are exempt from. 9. Sears later added a request for memoranda dealing with the contract successorship doctrine of Burns International Detective Agency, (NLRB), as well as cases dealing with lockouts occurring in multi-employer bargaining situations. Sears was then in the process of preparing an appeal to the General Counsel in Washington from a refusal by the Regional Director to file a complaint with the Board in response to an unfair labor practice charge earlier filed by Sears with the Regional Director in Seattle, Washington. The refusal was based upon an advice memorandum and involved a judgment about the timeliness of the withdrawal by Sears from a multi-employer bargaining unit. The letter sent by the Regional Director to Sears to explain the refusal stated that Sears' withdrawal had been untimely. Sears' appeal without the benefit of the documents sought was ultimately successful. A complaint was filed with the Board, and hearings were scheduled to commence on the complaint on November 9, 1971. Proceedings before the Board were delayed for a time by a stay issued by the District Court, later reversed by the Court of Appeals. Sears, ROEBUCK & Co. v. NLRB 153 U.S. App. DC 380 473 F2D 91 Cert. Denied, 415 U.S. 950, and the complaint was eventually withdrawn upon withdrawal of the underlying charge. Sears' rights under the Act are neither increased nor decreased by reason of the fact that it claims an interest in the advice and appeals memoranda greater than that shared by the average member of the public. The Act is fundamentally designed to inform the public about agency action and not to benefit private litigants. EPA v. Mink 410 U.S. 73 79 92, Renegotiation Board v. Bannercraft Clothing Co., 415 U.S. 124. Accordingly, we will not refer again to Sears' underlying unfair labor practice charge. Opinion of the Court. Disclosure under 5 U.S.C. 552 as intra-agency memoranda, which reflect the thought processes of the General Counsel's staff, and that they are exempt pursuant to 5 U.S.C. 552 as part of the investigative process. The letter said that appeals memoranda were not indexed by subject matter, and therefore the General Counsel was unable to comply with Sears' request. In further explanation of his decision, with respect to appeals memoranda, the General Counsel wrote to Sears on August 4, 1971, and stated that appeals memoranda which ordered the filing of a complaint were not final opinions. The letter further stated that those appeals memoranda which were final opinions, 1. Those in which an appeal was denied, and which directed that no complaint be filed, numbered several thousand, and that in the General Counsel's view they had no precedential significance. Accordingly, if disclosable at all, they were disclosable under 5 U.S.C. 552. Relating to identifiable records, the General Counsel then said that Sears had failed adequately to identify the material sought, and that he could not justify the expenditure of time necessary for the agency to identify them. On August 4, 1971, Sears filed a complaint pursuant to the Act seeking a declaration that the General Counsel's refusal to disclose the advice and appeals memoranda and indices thereof requested by Sears violated the Act, and an injunction enjoining continued violations of the Act. On August 24, 1971, the current General Counsel took office. In order to give him time to develop his own disclosure policy, the filing of his answer was postponed until February 3, 1972. The answer denied that the Act. Opinion of the Court. Required disclosure of any of the documents sought, but referred to a letter of the same date in which the General Counsel informed Sears that he would make available the index to advice memoranda, and also all advice and AP. Appeals memoranda in cases which had been closed, either because litigation before the board had been completed or because a decision not to file a complaint had become final. He stated, however, that he would not disclose the memoranda in open cases, that he would, in any event, delete names of witnesses and security-sensitive matter from the memoranda he did disclose, and that he did not consider the General Counsel's office bound to pursue this new policy in all instances in the future. Not wholly satisfied with the voluntary disclosures offered and made by the General Counsel, Sears moved for summary judgment, and the General Counsel did likewise. Sears thus continued to seek memoranda in open cases. Moreover, Sears objected to the deletions in the memoranda in closed cases, and asserted that many appeals memoranda were unintelligible because they incorporated by reference documents which were not themselves disclosed, and also referred to the circumstances of the case, which were not set out and about which Sears was ignorant. The General Counsel contended that all of the documents were exempt from disclosure as intra-agency memoranda within the coverage of 5 U.S.C. 552, and that the documents incorporated by reference were exempt from disclosure as investigatory files pursuant to 5 U.S.C. 552. The parties also did not agree as to the function of an advice memorandum. Sears claimed that advice memoranda are binding on regional directors. The General Counsel claimed that they are not, noting the fact that the regional director himself has the delegated power to issue a complaint. Opinion of the Court. The District Court granted Sears' motion for summary judgment and denied that of the General Counsel. The Court found that, although the General Counsel had delegated to the regional directors the power to file complaints, an advice memorandum constituted a pro tanto withdrawal of the delegation of that power. Accordingly, advice memoranda were held to constitute instructions to staff that affect a member of the public, which are expressly disclosable pursuant to 5 U.S.C. 552. Appeals memoranda were held to be final opinions. Both were held not to be intra-agency memorandums protected by 5 U.S.C. 552, since they were not expressions of a point of view, but the disposition of a charge. Documents incorporated by reference in the memoranda were held to have lost whatever exempt status they had previously. See American Mail Line, Ltd. v. Gulick, 133 U.S. App. DC 382, 389, 411 F2D 696, 703. The court then concluded that the case was a proper one for exercise of its injunctive powers under the Act, even though the General Counsel had voluntarily disclosed some of the material sought. The court noted that it had jurisdiction to enjoin the withholding of documents prospectively, in addition to ordering the production of documents already withheld. It referred to the fact that the General Counsel's office had a long-standing policy of non-disclosure, and that it still maintained that the policy was lawful, and that the current one of partial disclosure could be changed. And it referred to the fact that disputes had arisen about the deletions in the documents which had been disclosed voluntarily. Accordingly, the court ordered that the General Counsel make available to the public all appeals and advice memoranda issued since July 4th. Opinion of the Court. 1967-12 and any document expressly incorporated by reference. 3. Produce and compile, if necessary, indices of the memoranda. Produce explanatory material, including existing documents, in those instances in which a memorandum refers to the circumstances of the case. And cease deleting names, citations, or matter other than settlement suggestions from the memoranda without written justification. This decision was affirmed without opinion by the Court of Appeals for the District of Columbia Circuit on the basis of its decision in Grumman Aircraft Engineering Corp. versus Renegotiation Board. 157 U.S. App DC 121. 482 F2D 710. Rev'd Post, page 168. And we granted certiorari 417 U.S. 907, in both cases, and set them for argument together to consider the important questions of the construction of the Act as they relate to documents generated by agency decision-making processes. 3. It is clear, and the General Counsel concedes, that appeals and advice memoranda are at the least identifiable records, which must be disclosed on demand, unless they fall within one of the Act's exempt categories. It is also clear that, if the memoranda do fall within one of the Act's exempt categories, our inquiry is. Opinion of the Court. At an end, for the Act does not apply to such documents. Thus, our inquiry, strictly speaking, must be into the scope of the exemptions which the General Counsel claims to be applicable, principally Exemption 5 relating to intra-agency memorandums. The General Counsel also concedes, however, and we hold for the reasons set forth below, that Exemption 5 does not apply to any document which falls within the meaning of the phrase final opinion, made in the adjudication of cases. 5 U.S.C. 552. The General Counsel argues, therefore, as he must, that no advice or appeals memorandum is a final opinion made in the adjudication of a case, and that all are intra-agency memoranda within the coverage of Exemption 5. He bases this argument in large measure on what he claims to be his lack of adjudicative authority. It is true that the General Counsel lacks any authority finally to adjudicate an unfair labor practice claim in favor of the claimant. but he does possess the authority to adjudicate such a claim against the claimant through his power to decline to file a complaint with the board. We hold, for reasons more fully set forth below, that those advice and appeals memoranda which explain decisions by the General Counsel not to file a complaint are final opinions made in the adjudication of a case and fall outside the scope of Exemption 5, but that those advice and appeals memoranda which explain decisions by the General Counsel to file a complaint and commence litigation before the board are not final opinions made in the adjudication of a case, and do fall within the scope of Exemption 5. A. The parties are in apparent agreement that Exemption 5 withholds from a member of the public documents which a private party could not discover in litigation with the agency. EPA v. Mink 410 U.S. at 85 to 86. Since Opinion of the Court. Virtually any document not privileged may be discovered by the appropriate litigant, if it is relevant to his litigation, and since the Act clearly intended to give any member of the public as much right to disclosure as one with a special interest therein, id. At 7992, Sterling Drug, Inc. v. FTC, 146 U.S. App. DC 237, 243, 244, 450 F2D 698, 704, 705 S. Rep. number 813, page 5, HR Rep. number 1497, page 1. It is reasonable to construe Exemption 5 to exempt those documents, and only those documents normally privileged in the civil discovery context. The privileges claimed by petitioners to be relevant to this case are the generally recognized privilege for confidential intra-agency advisory opinions. Kaiser Aluminum and Chemical Corp. 5 United States, 141 CT CL 38, 49, 157 F Sup 939, 946, disclosure of which would be injurious to the consultative functions of government. Kaiser Aluminum and Chemical Corp. Supra at 49, 157 F Sup. At 946, EPA v. Mink Supra at 86 to 87, and the attorney-client and attorney work product privileges generally available to all litigants. Opinion of the Court. That Congress had the government's executive privilege specifically in mind in adopting Exemption 5 is clear. S. Rep. NO 813, page 9, HR Rep. number 1497, page 10, EPA v. Mink Supra at 86. The precise contours of the privilege in the context of this case are less clear, but may be gleaned from expressions of legislative purpose and the prior case law. The cases uniformly rest the privilege on the policy of protecting the decision-making processes of government agencies. Tennessean Newspapers, Inc. v. FHA, 464 F2D 657 660, Carl Zeiss Stiftung vs. VEEB Carl Zeiss Jenna 40. FRD 318, see also EPA v. Mink Supra at 86 to 87, International Paper Co. v. FPC, 438 F2D 1349 1358 to 1359, Kaiser Aluminum and Chemical Corp. vs. United States, Supra, at 49 157 F Sup. At 946, and focus on documents reflecting advisory opinions, recommendations and deliberations comprising part of a process by which governmental decisions and policies are formulated. Carl Zeiss Stiftung v. VEB Carl Zeiss Jenna Supra at 324. The point, plainly made in the Senate report, is that the frank discussion of legal or policy matters in writing might be inhibited if the discussion were made public, and that the decisions and policies formulated would be the poorer as a result. S. Rep. number 813, page 9. See also HR Rep number 1497, page 10, EPA v. Mink Supra at 87. As a lower court has pointed out, there are enough incentives as it is for playing it safe and listing with the wind, Ackerley v. Lay, 137 U.S. App. DC 133, 138, 420 F2D 1336, 1341, and as we have said in an analogous context, human experience teaches that those who expect public dissemination of their remarks may well temper candor with a concern for appearances. To the opinion of the court. Detriment of the decision-making process. United States v. Nixon, 418 U.S. 683, 705-17. Manifestly, the ultimate purpose of this long-recognized privilege is to prevent injury to the quality of agency decisions. The quality of a particular agency decision will clearly be affected by the communications received by the decision-maker on the subject of the decision prior to the time the decision is made. However, it is difficult to see how the quality of a decision will be affected by communications with respect to the decision occurring after the decision is finally reached. And therefore equally difficult to see how the quality of the decision will be affected by forced disclosure of such communications, as long as prior communications and the ingredients of the decision-making process are not disclosed. Accordingly, the lower courts have uniformly drawn a distinction between pre-decisional communications, which are privileged, e.g., Boeing Airplane Co. v. Coggeshall, 108 U.S. App. DC 106, 280 F2D 654, O'Keefe v. Boeing Co. 38 FRD 329, Walled Lake Door Co. v. United States, 31 FRD 258, Zacher v. United States, 227 F2D 219, 226 Cert. Denied, 350 U.S. 993, Clark v. Pear. Our remarks in United States v. Nixon were made in the context of a claim of executive privilege resting solely on the Constitution of the United States. No such claim is made here, and we do not mean to intimate that any documents involved here are protected by whatever constitutional content the doctrine of executive privilege might have. 2. Our emphasis on the need to protect pre-decisional documents does not mean that the existence of the privilege turns on the ability of an agency to identify a specific decision in connection with which a memorandum is prepared. Agencies are, and properly should be, engaged in a continuing process of examining their policies. This process will generate memoranda containing recommendations which do not ripen into agency decisions, and the lower courts should be wary of interfering with this process. Opinion of the Court. Sun, 238 F. Sup. 495, 496. And communications made after the decision and designed to explain it, which are not. Sterling Drug, Inc. v. FTC 146 U.S. App. DC 237 450 F 2D 698 GSA v. Benson. 415 F2D 878, 881, Bannercraft Clothing Company. 5. Renegotiation Board, 151 U.S. App. DC 174, 466. F2D 345 revved on other grounds 415 U.S. 1 Tennessean Newspapers, Inc. v. FHA Supra. See also S. Rep. number 1219 88th Song. 2D Session 7 and 11.2. This distinction is supported not only by the lesser injury to the decision-making process flowing from disclosure of post-decisional communications, but also in the case of those communications which explain the decision, by the increased public interest in knowing the basis for agency policy already adopted. The public is only marginally concerned with reasons supporting a policy which an agency has rejected, or with reasons which might have supplied but did not supply the basis for a policy which was actually adopted on a different ground. In contrast, the public is vitally concerned with the reasons which did supply the basis for an agency policy actually adopted. These reasons, if expressed. 20. This report was prepared in connection with a Senate bill identical to the one which led to the Act, which was eventually passed by the 89th Congress. Opinion of the Court. Within the agency constitute the working law of the agency and have been held by the lower courts to be outside the protection of Exemption 5. Bannercraft Clothing Co. vs. Renegotiation Board 151 U.S. App. D.C. at 181, 466 F2D at 352, Cuneo vs. Schlesinger. 157 U.S. App DC 368, 484 F2D 1086 Cert. Denied Subnom. Rosen vs. Vaughn 415 U.S. 977 Ash Grove Cement Co. v. FTC 371 F. Sup. 370 Afton Part and Revd in Part 167 U.S. App. DC 249, 511 F, 2D 815. Exemption 5, properly construed. Calls for disclosure of all opinions and interpretations which embody the agency's effective law and policy, and the withholding of all papers which reflect the agency's group thinking in the process of working out its policy and determining what its law shall be. Davis, the Information Act, a preliminary analysis, 34 U.Chi. L. Rev. 761, 797, note, Freedom of Information Act and the exemption for intra-agency memoranda, 86 Harv. L. Rev. 1047. This conclusion is powerfully supported by the other provisions of the Act. The affirmative portion of the Act, expressly requiring indexing of final opinions, statements of policy and interpretations which have been adopted by the agency, and instructions to staff that affect a member of the public, 5 U.S.C. 552. Represents a strong congressional aversion to secret law, Davis, Supra, at 797, and represents an affirmative congressional purpose to require disclosure of documents which have the force and effect of law. H.R. Rep. No. 1497, page 7. We should be reluctant, therefore, to construe Exemption 5 to apply to the documents described in 5 U.S.C. 552. And with respect at least to final opinions which not only invariably explain agency action already taken or an agency decision already made, but also constitute final disposi. Opinion of the Court. Tie-ins of matters by an agency, see Infra, at 158 to 159, we hold that Exemption 5 can never apply. It is equally clear that Congress had the attorney's work product privilege specifically in mind when it adopted Exemption 5, and that such a privilege had been recognized in the civil discovery context by the prior case law. The Senate report states that Exemption 5 would include the working papers of the agency attorney and documents which would come within the attorney-client privilege if applied to private parties, S. Rep. Number 813, page 2, and the case law clearly makes the attorney's work product rule of Hickman v. Taylor, 329 U.S. 495, applicable to government attorneys in litigation. Kaiser Aluminum and Chemical Corp. v. United States, 141 CT. CL at 50, 157 F Sup at 947 United States versus Anderson, 34 FRD 518, Filt Securities Corp. v. New York Stock Exchange, 57 FRD 133, J.H. Rutter Rex Manufacturing Co., Inc. v. NLRB, 473 F2D 223 Cert. Denied, 414 U.S. 822. Whatever the outer boundaries of the attorney's work product rule are, the rule clearly applies to memoranda prepared by an attorney in contemplation of litigation which set forth the attorney's theory of the case and his litigation strategy. In Renata 410 F2 di 187, cert. Denied subnom, Montecatini Edison versus E.I. DuPont de Nemours & Co., 396 U.S. 836, State ex rel. Dudek versus Circuit Court for Mill. Opinion of the Court. Waukee County 34 WIS 2D 559, 150 NW 2D 387, Hickman versus Taylor Supra at 510 to 511. B. Applying these principles to the memoranda sought by Sears, it becomes clear that Exemption 5 does not apply to those appeals and advice memoranda which conclude that no complaint should be filed and which have the effect of finally denying relief to the charging party. But that Exemption 5 does protect from disclosure those appeals and advice memoranda which direct the filing of a complaint and the commencement of litigation before the board. Under the procedures employed by the General Counsel, advice and appeals memoranda are communicated to the regional director after the General Counsel, through his advice and appeals branches, has decided whether or not to issue a complaint, and represent an explanation to the regional director of a legal or policy decision already adopted by the General Counsel. In the case of decisions not to file a complaint, the memoranda effect as final a disposition, see discussion, infra, at 158 to 159, as an administrative decision can representing, as it does, an unreviewable rejection of the charge filed by the private party. Vaca versus Sipes 386 U.S. 171. Disclosure of these memoranda would not intrude on pre-decisional processes, and protecting them would not improve the quality of agency decisions. Since when the memoranda are communicated to the regional director, the General Counsel has already reached his decision, and the regional director who receives them has no decision to make. He is bound to dismiss the charge. Moreover, the General Counsel's decisions not to file complaints together with the advice, opinion of the court, and appeals memoranda explaining them, are precisely the kind of agency law in which the public is so vitally interested and which Congress sought to prevent the agency from keeping secret. 22. The Committee on Practice and Procedure of the American Bar Association's section of Labor Relations Law has said in its 1970 report, where the advice branch directs the regional director to issue a complaint, or where a regional director's dismissal is reversed on appeal, and a complaint is subsequently issued, the subject matter, theory, and interpretation will ultimately be ventilated through the course of hearing, trial examiner and board decisions, and perhaps review and adjudication in the courts. It is in all the remaining cases. The General Counsel argues that he makes no law, analogizing his authority to decide whether or not to file a complaint to a public prosecutor's authority to decide whether a criminal case should be brought, and claims that he does not adjudicate anything resembling a civil dispute. Without deciding whether a public prosecutor makes law when he decides not to prosecute, or whether memoranda explaining such decisions are final opinions. See infra at 158 and N25. It is sufficient to note that the General Counsel's analogy is far from perfect. The General Counsel, unlike most prosecutors, may authorize the filing of a complaint with the board only if a private citizen files a charge. 29 U.S.C. 153 and 160, 29 CFR 101.2, Auto Workers v. Schofield, 382 U.S. 205, 219, NLRB v. Indiana and Michigan Electric Co., 318. U.S. 918. Unlike the victim of a crime, the charging party will, if a complaint is filed by the General Counsel, become a party to the unfair labor practice proceeding before the board. 29 CFR 102.8, Auto Workers v. Schofield Supra at 219. And if an unfair labor practice is found to exist, the ensuing cease and desist order will, unlike the punishment of the defendant in a criminal case, coerce conduct by the wrongdoer flowing particularly to the benefit of the charging party. For these reasons,